Hello and welcome to Timmy Mac Law with me, Mr. McClellan. For this video, we are going to look at the offence of assault occasioning actual bodily harm. Now, just before we carry on with this particular video, make sure you go back and look at my videos on assault and battery, because if you don't do that, this stuff isn't going to make too much sense to you. So make sure you go back and watch the assault and battery videos. Now, in terms of assault occasioning actual bodily harm, it is a statutory offence. It comes under Section 47 of the Offences Against the Person Act 1861. It's sometimes known as a Section 47 offence under the OAPA, the Offences Against the Person Act 1861. It is a triable either way offence, so it can be heard in the magistrates or the Crown Court, and it has a maximum sentence of 5 years, so it is pretty serious. In terms of a definition of assault occasioning actual bodily harm, it is where the defendant intentionally or recklessly commits an assault or battery which causes ABH. I'll say that again. It is where the defendant intentionally or recklessly commits an assault or battery which causes ABH. And as ever, in order to fully understand this offence, we need to look at its practical application by analysing case law. And we'll look at each element, each key word, by looking at the Actus reus to begin with, and it starts with the word assault. So what does an assault mean? Well, you should know this because you've watched the video. On an assault, it is where the victim apprehends the use of immediate and unlawful force against them. So in other words, it is where the victim expects or predicts that force will be used against them. So look out for an assault, equally look out for a battery, and this is where the defendant applies unlawful force upon the victim. So, in simple terms, it is unwanted touching. Now, both these separate offences, assault and battery, are your starting point when it comes to determining the offence of assault occasioning actual bodily harm. So look out for an assault and battery first, and I'll reiterate that point at the end of this video. The next Actus reus element is the word causes, which quite simply means occasioning. Hence, assault occasioning actual bodily harm, assault causing actual bodily harm. And this was determined by the case of Roberts in 1971. And this is where the victim was a 21-year-old woman who happened to get into a car with a stranger at 3 a.m. in the morning, a pretty stupid thing to do, in order to get from one party to another party. Now, when both the defendant and victim were in the vehicle, the defendant decided to make sexual advances against the victim. First of all, by rubbing the clothing of the victim. Now, quite understandably, the victim was a little bit scared at this particular action and decided, in order to escape, to throw herself out of the vehicle. Now, in throwing herself out of the vehicle, because of the unwanted touching, because of the battery, it led to injuries which constituted actual bodily harm. Now, the defendant argued that they had the intention only for the battery, or indeed recklessness with respect to the battery, but they did not have the intention, or indeed were not reckless, when it came to the injuries which constituted ABH as caused by the victim throwing herself out of the car. But that argument put forward by the defendant didn't matter. All you need to have is the intention or the recklessness to cause the battery or indeed an assault, and if that leads to injuries which constitute actual bodily harm, you can therefore be liable for assault occasioning actual bodily harm. So, in other words, the assault or the battery, if it causes ABH, then the offence will be assault occasioning actual bodily harm, as determined by the case of Roberts. Now, the next Actus reus element is that phrase ABH, actual bodily harm. What does that actually mean? Well, let me throw a quotation out to you. It means any hurt or injury calculated to interfere with the health or comfort of the victim, provided it is not merely transient or trifling. Now, they are the words of the judge from the case of Miller, 1954. It is not the case of Miller, 1983, that case which was all to do with emissions, so don't get confused with that particular Miller case. It is Miller, 1954. Now, they are the words of the judge, and you should retain these to your memory, okay? They really are worth remembering. An examiner will look out for that particular quotation, so it's very, very important that you remember it. Now, in terms of the case of Miller, this is where the defendant forced himself upon his wife. Now, his wife had actually petitioned for divorce a couple of years earlier, but before the petition hearing for the divorce was heard, the defendant decided to force himself onto his wife and have unconsensual or non-consensual sex with his wife. Now, in most other cases, or indeed in all other cases, that would constitute as rape. But in 1954, it was perfectly lawful to force yourself upon your wife. You couldn't effectively rape your wife, and you can therefore, as the defendant, use the lawful excuse of you were married to your spouse, and therefore you can effectively have non-consensual sex with your spouse. Sounds a little bit crazy. The law in relation to that was changed in 1991 following the case of Crown versus R. So look out for that case in terms of your future learning. Crown versus R. It took away that particular defense or excuse when it came to forcing yourself upon your wife. Okay, so it is illegal now, but it wasn't illegal in 1954. So that's one element of the case of Miller in relation to the non-consensual sex. The other element to the case of Miller is that because the victim was so hysterical, and indeed she argued that she suffered from nervous shock because of what the defendant, her husband, had done to her, that constituted ABH. Now, in deciding to kind of unpick the puzzle of this particular case, the judge came out with that quotation as to what ABH could actually be. The defendant was not found guilty of the rape of his wife, because you couldn't rape your wife in those days, but he was found liable for the ABH because the nervous shock constituted actual bodily harm, and this was defined effectively by the judge through that quotation. So I'll say that quotation one more time simply because it's so important. Any hurt or injury calculated to interfere with the health or comfort of the victim, provided it is not merely transient or trifling. So it's got to be some sort of significant harm. Not necessarily the most serious harm, because that would constitute GBH, which we'll look at later, but certainly harm or injury which is significant in itself. It can't be fleeting, that would be merely transient. It can't be trivial, because that would be rather trifling. So it's got to be some sort of significant injury. And I'll give you some examples in practical terms to look out for a little bit later on. Now, moving on, the case of Chan Fook, careful how you say that, the case of Chan Fook actually built upon that particular definition of ABH, and in that case, the judge put forward that ABH is any injury which should not be so trivial as to be wholly insignificant. Hence, the injury or the hurt has to be significant, and if it's not, well, it really doesn't constitute itself as ABH. It's going to be more akin perhaps to a battery. Okay, so I'll explain the case of Chan Fook in just a second, because we're going to return to it, quite an unusual case, so we'll move on ever so slightly. ABH does include cutting off or indeed paint or putting paint in someone's hair. Now, this comes from the case of Smith 2007. The case of Smith 2007 actually related to the defendant cutting off the hair of his ex-girlfriend. Now, I would suggest it would be a significant lock of hair. It was actually his ex-girlfriend's ponytail, so you can understand why she was quite upset by that. And in the abita mentioned by the judge, the thing said, by the way, was that paint in someone's hair could also constitute ABH. Again, I would suggest that it's going to be a significant amount of paint, just like cutting off a significant amount of hair would constitute ABH. If it's anything less than a significant amount of paint or anything less than a significant amount of hair that you're cutting off, it could be argued that it's going to be relatively trivial as a form of injury or hurt. Or indeed, is cutting off someone's hair or putting paint in their hair actually an injury or hurt? Well, no, it's not. And therefore, you've got the definition as put forward by the judge in the case of Miller being extended just a little bit. And therefore, we can take to mean that ABH means any hurt or injury, yes, but also damage. So if you're cutting off someone's hair, putting paint in someone's hair, and that constitutes ABH, it really comes under the word damage. If the damage does constitute itself as ABH, you therefore can be liable for the offence of assault. occasioning actual bodily harm. So any hurt, injury or damage is what you want to look out for. Moving on, and this is where the case of Chan Fook now comes into play. We've got psychiatric harm can actually be under the remit of actual bodily harm. So it doesn't need to be a physical injury to constitute ABH. It can be psychiatric harm, it can be a psychiatric injury, which of course is some sort of mental injury. But I'd use the term psychiatric harm. Now in the case of Chan Fook, this sounds to me like the exchange visit from hell. It was where a French student came to the UK to stay with the defendant and yet was accused of stealing the defendant's fiance's engagement ring. Now, at this particular suspicion, the defendant put the victim in a locked room, interrogated the victim as to the whereabouts of this engagement ring, and struck the victim several times. So you can understand why this French exchange student was pretty scared at this moment in time. Now, in order to escape from that situation, the French student decided to tie some sheets together and some curtains together in order to make a rope, hang it off the curtain pole and climb down the outside of the building. Whilst you may understand that particular predicament of the exchange student, obviously they were a little bit nervous at the situation, the prosecution for the case against the defendant decided not to necessarily constitute on the injuries, the physical injuries, which were caused to the victim. Now the victim, in climbing down their makeshift rope down the side of the building, actually fell off and broke some bones, fractured some limbs, and indeed broke their hip, I think, and therefore you'd normally think that would come under the remit of ABH. The reason why the prosecution didn't focus on those injuries, though, was because it was debatable as to whether, in creating that rope, it was reasonable for the defendant to do that, and that could have perhaps constituted as an intervening act, a novus actus interveniens, which would have broken the chain of causation. So the prosecution decided not to frame the case in relation to the physical injuries caused to the victim. They decided to frame the case in terms of the psychiatric harm which they had argued had been caused to the victim. They stated that the victim, rather understandably, had been fearful and panicked because of the way the defendant had acted towards them. Rather unfortunately, though, for the victim, the defendant was found not guilty of assault occasioning actual bodily harm because mere emotions, as determined by the judge, such as fear and panic, did not constitute actual bodily harm. It has to be a recognisable medical condition, and therefore it needs to be clinically diagnosed. And being fearful, being panicked, is not necessarily a diagnosis of a medical psychiatric harmful condition, and therefore the defendant was found not guilty of causing actual bodily harm to the victim. So quite a strange case, and indeed quite a strange outcome, but nevertheless it did determine that psychiatric harm did constitute ABH. It just so happened, sadly for the victim, that the judge didn't agree that they'd suffered from psychiatric harm. Mere emotions is what they had suffered from in terms of panic and indeed fear. Now, moving on, and this is where we can give you some concrete examples of what ABH normally looks like, and this is how it will generally appear in the scenarios that you'll face in the exam. More often than not, ABH will look like bruising, significant bruising, not necessarily minor bruising or just a single bruise, but bruising which is deemed to be significant. Equally, it can be fractures of minor bones. So I would suggest the fracturing of fingers, maybe a broken nose, toes even, but not of major limbs, because that's probably going to constitute GBH. Okay, so minor fractures, and indeed the loss of consciousness, albeit the loss of temporary consciousness, as defined in the case of T versus DPP 2003. And this is where the victim was chased by the defendant and others, so it sounds to me like a gang situation, and indeed the victim on the floor, covering his head so as to protect himself, was kicked several times by the defendant and they lost consciousness, albeit for only several minutes. So a temporary loss of consciousness does constitute ABH. I guess anything longer than a few minutes, so maybe 5 to 10 and beyond that minutes, then that would constitute GBH. So momentary loss of consciousness, probably going to fall under the remit of ABH. And there will be the major examples that you'll get, coupled with psychiatric harm. Do look out for that, because it does quite often appear in scenarios as a way to just trip you up. Everyone's looking out for physical injuries when actually it can be psychiatric harm, and make sure you couple that with the case of Chan Fook. Very, very important. In terms of the mens rea elements, well, we have the word intention. It's the intention to commit an assault or battery. And I'll re-emphasise that it is not the intention necessarily to commit actual bodily harm. It is just the intention to commit the assault or the battery, which in themselves are quite minor offences. But if it leads to actual bodily harm as a consequence for the victim, then the offence will be assault occasioning actual bodily harm. And indeed, recklessly, that can be defined as subjective recklessness, obviously Cunningham recklessness, as you'll have looked at when you studied the mens rea and the case of Cunningham. So subjective recklessness is where the defendant is conscious that there is a risk to their behaviour, but they consciously decide to take that risk anyway. And again, let me emphasise one more time, it is just the subjective recklessness to commit an assault or battery. Not being reckless to commit ABH, but just being reckless to commit the assault or battery. So both the assault and the battery, as we mentioned up here, that comes first. So find evidence of the assault and battery and then look at the extent of the injuries. And if you think the extent of the injuries constitute ABH, then you can conclude that the offence is assault occasioning actual bodily harm. And, you know, this is my advice that I'm giving you here. There is no need for the defendant to possess intention or recklessness to commit ABH. They simply need the intention or recklessness to commit the assault or battery. And it just so happens that leads to the ABH. That comes from the case of Savage, 1991. We met this case before when we looked at the offence of battery. And indeed, it's where the defendant decided to pour the contents of their pint glass over the victim, but in doing so and probably making that sort of action, the pint glass slipped out of their hand and caused a physical injury to the victim. Now, the defendant argued that they had no intention or indeed weren't necessarily subjectively reckless when it came to the causing of the ABH, but that argument didn't stand up in court because they did have the intention or were at least subjectively reckless when it came to causing the battery, the pint glass slipping out of their hand, okay? So, very, very important. This is why I put it in capital letters. It's a common mistake for students to make. You don't need the intention or indeed be reckless when it comes to causing the ABH. You just need the intention or to be reckless, subjectively reckless when it comes to causing the assault or the battery. So start off with finding evidence of the assault and battery first. There's your starting point, and then look at the extent of the injuries and do they constitute ABH. And if they do, well, you know what offence to go for. Assault occasioning actual bodily harm. And there's the advice again. I'm not going to repeat that. You can see it in black and white. Final aspect of this, guys, get your terminology right as well, okay? So, on most occasions, you will have a battery which leads to ABH. So you'll have unwanted touching, maybe a punch in the face, which is pretty unwanted, which leads to actual bodily harm. Now, when you get that, make sure you write down assault brackets battery. So you're actually identifying the form of common assault which has led to the ABH. So if you get a battery, which you normally will do, which leads to ABH, the way to write it is assault brackets battery occasioning actual bodily harm. Occasionally, though, you can have an assault. So maybe the victim just apprehends the use of immediate and lawful force against them, and because their fear is to such an extent, it causes perhaps a psychiatric injury or psychiatric harm that can constitute ABH. And where you have ABH being caused by an assault without the battery, it may be uncommon, but it sometimes does happen. You just need to write assault occasioning actual bodily harm. So make sure you get your terminology right when it comes to writing your scenario answers. Hope that's good for you. Thank you very much.